Welcome to the Judicial Committee of the Privy Council. Today is the second day of an appeal in the case of Betamax Ltd and State Trading Corporation. Yesterday we heard the submissions of the appellants, and today Mr. Chu Choi QC is continuing the submissions on behalf of the respondents. Mr. Chu Choi, good morning. I would be very grateful if the board could be assisted in understanding what I think is an agreed position, which is that this is an international arbitration. And in particular, if you could explain why it is an international arbitration if Betamax Limited is a Mauritian company, and also whether the fact that it's an international arbitration has any impact on the scope of public policy. Secondly, in relation to the statutory interpretation question to which you'll be turning, I don't think the board will have any difficulty in recognizing that the Supreme Court's reasoning did mention the submission that had been made that there was a distinction to be drawn between major and minor contracts. Where the board, I think, would welcome some help is as to the means by which Regulation 2A made the distinction between the major and minor contract. In other words, how it had the effect of bringing in the prescribed sum in column 3 so that major contracts were excluded from the exemption. Thank you.
Thank you, my lord. May I deal with it in this way? I will obviously have to address what is probably the most central question that you've just raised, the second of your questions in the context of the interpretation of Regulation 2A, in the course of making my submissions during Ground 2, which I will resume in a moment. I have a few points of consolidation, if I may put it that way, in relation to Ground 1 that I want to spend a few minutes on at the outset this morning. In relation to the question why the arbitration was agreed between the parties to be an international arbitration, I'm afraid I don't have the relevant points to hand at the moment in relation to that issue. It's no doubt buried in my memory, buried deep in my memory somewhere. But my recollection is that that was indeed agreed to be the position. And no doubt I will be getting some messages as I carry on with my submissions this morning telling me why that is so.
Mr. Chu Choi, I don't wish to detain you on that point, but if necessary, if the parties could produce a joint note explaining the basis of that agreement after the hearing, that would be perfectly adequate.
I'm grateful, my lord. So, my lord, the additional points I wanted to raise in relation to Ground 1 before I resume on Ground 2 are these. I didn't expressly deal yesterday with Mr. Howard's reference to the Rokeby decision. We deal with that at paragraphs 41.1 and 41.2 of our written case. I won't repeat that, but 2 points I want to emphasize are, first, that the Singapore Court of Appeal's disapproval was of the first instance judge's approach in re-examining the facts of the case in Rokeby, and in particular the factual question of the intention with which certain services had been provided. The point being that the application of the relevant securities and futures provisions turned in that case on the factual purpose for which the relevant services were provided. So in that respect, therefore, Rokeby was rather like the example we were considering yesterday of whether one is dealing with a contract below or above the prescribed amount.
I think Lady Arden wishes to ask a question.
Yes, thank you. Lady Arden, I'm sorry.
Can you hear me? That's it.
No, I'm afraid I couldn't hear you.
No. Let me just put a very short question, if you can hear now. And
Yes.
that is, I understand how you put it, that in this AJU and AJT, the Singapore Court of Appeal was criticising the judge for reopening and re-entering into the questions of fact decided in the arbitration. Can you just in a very brief sentence or two explain why it is different if the arbitrator has decided a point of law, assuming for the moment and putting on one side the public policy exception or any other exception to reopening an award? Why is it different from the point of law if it's within the jurisdiction of the arbitrator to decide it?
The answer is it's not different if it's a point of law that does not engage public policy considerations, and in particular, public policy considerations of the relevant state. If it does, because the question of what the public policy of the relevant state is a question that is fairly and squarely raised by the subsection, by the public policy provision, then the courts take the view that that must be a question that is capable of being reviewed by the court.
But if the court is exercising a provision, a power given by a provision which derives from a convention, the court would presumably apply the presumption that the exception is to be interpreted in accordance with the exception, with the convention, which the legislation implements.
Oh, absolutely, yes. And indeed, as I think is common ground, Section 39, for example, and its equivalent in Article 34 of the Model Law, essentially reproduces the grounds for refusing enforcement under the New York Convention. So it's simply that those grounds very often surface both as grounds for refusing for annulling or setting aside an arbitral award at the supervisory stage, but also surface at the enforcement stage throughout the entire universe of New York Convention territory members. The second point I wanted to make in relation to Rokeby is that there was no suggestion by the Singapore Court of Appeal, either when dealing with Rokeby or elsewhere in its judgment in AJU, that a statute cannot be the source of public policy for the purposes of the public policy exception under the modern law. That's self-evident, but it bears reiteration. The second point I wanted to raise in relation to ground one is this. I said in answer to a question from Lord Hodge that there was no reported case before the board in which a supervisory or enforcing court had applied the public policy exception in order to review an earlier decision of an arbitral tribunal on a point of statutory construction. That, in fact, is incorrect because the board has the benefit of Mr. Justice Tugendhat's decision in a case called Accentuate Limited and Asigra Inc., which is at page 3086 and is an interesting decision which I think the board is going to find helpful. I'm going to try and summarize. The case is a little involved, but the basic facts are set out at paragraphs 1 to 10. But essentially, what that case shows is that when the court is faced with a sufficiently fundamental rule of law, more often than not contained in a statute of some kind, an earlier determination by an arbitral tribunal based on that tribunal's interpretation of the relevant legislation that the rule of law does not apply to the case before the tribunal is not a determination that is binding on the court for the purposes of the public policy exception. Just to set the case in context very briefly, the dispute in that case, and that appears from paragraphs 1 to 10, the dispute was between an English distributor and a Canadian licensor of software products. They were parties to a master reseller agreement, which contained MRA, which contained an arbitration clause and an Ontario law governing law clause. The MRA was terminated by the licensor, leading to the intimation of a claim by the distributor for compensation under the Commercial Agents Regulations 1993, under English law. In an effort to preempt the commencement of such a claim in the English courts, the Canadian licensor gave notice of arbitration in reliance on the arbitration clause in the MRA. And the licensor claimed in the arbitration a declaration from the arbitral tribunal that the distributor had no claims against the licensor under the MRA upon any basis, including pursuant to the Commercial Agents Regulations. The distributor defended the claim in the arbitration, but also commenced its own claim in the English courts for compensation under the regulations. The licensor applied to stay the court claim under Section 9 of the English Arbitration Act and succeeded before the first instance judge, the district judge. But that judge gave permission to appeal, with the result that the appeal was ultimately heard by Mr. Justice Tugendhat. Meanwhile, in the arbitration, the distributor resisted the licensor's claim for a declaration of non-liability on the basis that the arbitration proceedings were essentially pointless because the English courts would not be bound by any finding of the tribunal that there was no claim under the regulations. In the alternative, the distributor also counterclaimed for compensation under the regulations. The licensor succeeded in its principal contention before the tribunal that since the MRA was governed by Ontario law, there could not be any claim under the regulations, which formed part of English law. And the tribunal's finding is recorded in the judgment of Mr. Justice Tugendhat at paragraph 73. In particular, within the quotation at paragraphs 19 and 20, the board will see the gist of the tribunal's findings in relation to the interpretation, meaning, and effect of the Commercial Agents Regulations. And obviously, in reaching the decision that you can see in paragraphs 19 and 20, the tribunal plainly had to interpret the regulations and determine their character and effect, and whether they displaced the operation of the Ontario law clause. So coming back to the English court claim, the licensor, being now in possession of an actual award in its favor, relied on the award by way of defense to the distributor's ongoing court claim under the regulations, with the distributor responding by relying on the public policy defense under Section 103 of the Arbitration Act. And the board will see that at paragraphs 67 and 68 of the judgment. The licensor was relying on the tribunal's award by way of defense, or otherwise in England and Wales, and then there's a quotation of Section 103. And this led the judge to consider the decision of the European Court in the case of Ingmar, which the judge cites at paragraph 74. And you will see that, in particular, the judge highlights the principle enunciated by the then ECJ, that it is essential for the community legal order that a principle established in a non-member country whose commercial agent carries on his activity within the community cannot evade those provisions by the simple expedient of a choice of law clause. And over the page, or onto the next paragraph, a quotation from the Advocate General's opinion, confirming the mandatory nature of Articles 17 and 18 of the regulations, or the directive that gave rise to the regulations, and confirming that the directive requires the application of mandatory provisions, notwithstanding any choice to the contrary. What the judge then does is, in the light of the European jurisprudence, he summarizes the distributor's arguments based on that jurisprudence at paragraphs 76 to 79, which include citation of the Claro decision that I referred to yesterday, as well as Eco-Swiss in paragraph 78, which were decided in relation to other provisions of EU law, which formed part of English law that was said to be mandatory in nature and qualified for public policy purposes. And the judge then at paragraphs 80 to 86 recited the licensor's contrary arguments, but then concluded at paragraph 87, I prefer the submissions for the distributor. In other words, the submissions founded on the European jurisprudence that irrespective of what may have been agreed, the regulations, if they otherwise apply on their own terms to the case in point, would then take precedence and would essentially displace or override the actual choice of law clause. In paragraph 88, you will see that the judge says the decision in Ingmar requires the court to give effect to the mandatory provisions of EU law, notwithstanding any provision to the contrary on the part of the contracting parties, etc. And the overall conclusion at 92 to 93 confirms that position. And obviously, that case was a case where the only issue that the judge was considering was whether the distributor, who had sought permission to serve out on the Canadian licensor, had a good arguable case for the purposes of the service out order.
Yes, I think Mr. Howard is wanting to interject at this point.
I'm sorry. Yes, sorry.
Mr. Howard.
Yes, my lord. Case, paragraph 89, which we've skipped over, the case is actually about whether an arbitration clause was null and void. In other words, it's a case all about jurisdiction, as with Claro, when you come back to look at it. Their case is not about review, but about validity of an arbitration clause, which is under EU law was held to be invalid.
Well, it is correct that there was that aspect of the case as well, but it is incorrect of Mr. Howard to suggest that that was either the only point or the determinative point of the case. It wasn't. In addition to the arbitration agreement issue, there was also the question of choice of law, because choice of law was critical to the question whether or not the regulations could be seen as governing the rights and liabilities of the parties, as opposed to Ontario law being the governing law. And you may recall in that regard that at paragraph 73, quoting from paragraphs 19 to 20 of the award, that was the precise point that was being made by the arbitrators. So the only reason why I've taken a bit of time to go through this case is that this is a clear instance in my submission of the English court espousing the reviewability of a tribunal's interpretation of a statute that is alleged to be the source of the relevant public policy.
Mr. Chuchoy, might it not be said that this is another example of CJEU jurisprudence, where their legal order prevails over what might otherwise be the rules of private international law? Because the judge makes clear at paragraph 79 that he sees himself acting as a community court.
Well, Your Lordship is right in relation to the question of characterization of the regulations. That was a characterization that was based on EU law. But EU law is English law for this purpose, or was for the purposes of that case. But secondly, and more importantly for present purposes, the public policy provision that was being applied by the judge was not an EU law provision, but was an English law provision contained in section 103 of the Arbitration Act. The relevant point was simply that, forgive me, Lady Arden.
No, sorry, only when you've come to the end of your response to Lord Hodge.
Thank you, my lady. I'll just finish the point. So the European aspect, if I can put it that way, the European dimension was not relevant to the question of the scope of the court's power of review under section 103. It was only relevant to the question whether the underlying statute that was said to be the source of the public policy could properly be seen as being relevant public policy for the purposes of section 103. But that was a different point. That point doesn't really go to the bone of contention in the context of ground one. My lady, Lady Arden had a question.
Thank you so much. I was just going to draw your attention to the fact that EU law takes a point which domestic law in the UK does not, namely that the law of the European Union is unitary and you cannot resolve questions in principle by arbitration of European Union law because there's no right of appeal to the member state and up to the Court of Justice. It's not brought into the system, and that is why the choice of law clause was struck down. And what the court was saying in the CJEU was that the arbitration clause couldn't be used either because the arbitrators couldn't determine EU law, had to be done by the courts of a member state, and which could refer a matter, ask for the opinion of the Court of Justice. And that's a very different approach to common law courts.
Well, your ladyship is entirely right about the unitary nature of the EU legal system and the significance within that system, therefore, of determinations by the court. But we know from both AJU and Sinocor that the question of what the public policy of the relevant state is a matter for the court. In that regard, it is not a matter. Arbitrators do not determine what the public policy of a state is.
I wasn't questioning that point. What I think I'm really moving on to is what is the New York Convention view of public policy? What is the threshold that must be met? Because the mere fact that the CJEU has its own threshold, which is derived from different principles, speaking for myself, doesn't really help me. What I need to know is what the New York Convention sets as the bar.
That I agree is moving away from the question of reviewability and is focusing on the question of, well, how important and how fundamental must the statute be in order to be appropriately regarded as forming relevant public policy for the purposes of the section. That I understand. That is not ground one, however. That is ground three. And I'll come back to that if I may. But of course, I entirely accept that that's an important question. But what there can be no doubt of in relation to that question in the context of ground one is that that question, namely whether the relevant statute is sufficiently fundamental and important to the relevant legal system so as to constitute public policy for the purposes of Section 39, that question is a question for the court. It's not a question for the arbitrators. And so that is where, therefore, I say the point rests so far as ground one is concerned. Three final points in relation to ground one before I get on to ground two. Regarding the argument that the court under Section 39 is concerned with whether the award, rather than the contract per se, conflicts with public policy, I do ask the board to bear in mind the passages we've already referred to in AJU and Sinocor, approving of the analysis in Dicey, which show very clearly that the court is not precluded from reviewing whether the contract itself conflicts with public policy, because the contract is what gives rise to the award, and the award is based on the contract. Fourthly, I just want to briefly consolidate what I said in relation to Mr. Howard's acceptance in answer, I think, to a question from Lord Leggett, that if the arbitrator had found that the PPA applied to the COA, but that did not render the COA unenforceable, the Supreme Court would have been entitled to go on to consider whether the award in fact conflicted with Mauritian public policy. In other words, whether the arbitrator had got it wrong on the question of the consequences of the PPA applying the COA. So the situation, therefore, is this, that Mr. Howard accepts that the Supreme Court would have been entitled to reconsider and determine for itself two aspects. First, whether on the true interpretation of the PPA, the effect of a breach of it is to render the COA illegal and unenforceable. And two, whether on the true interpretation of the PPA, the Act was properly to be regarded as representing the public policy of Mauritius. What he does not accept, however, is that the Supreme Court was entitled to reconsider for itself whether the PPA on its true interpretation applied to the COA. So those are the three aspects of statutory interpretation that are essentially engaged by the public policy debate we're having. And in short, we say there is simply no principled distinction between these three different aspects of statutory interpretation. Because in a case where the putative source of public policy is said to be a statute, any question as to the proper interpretation of the statute and its effect on the underlying contract on which the award is based is intrinsically a matter for independent determination, review and determination by the court under Section 39. I'm sorry, I realize I did touch upon that yesterday, but I just wanted to consolidate my points on that. The final point I want to add in relation to ground one is that none of the foregoing analysis in my submission is undermined by the fact that the public procurement legislation may permit disputes under the relevant procurement contract to be arbitrated. The operation of Section 39 presupposes the existence of an arbitration agreement. but the existence of such an agreement does not per se bear on the scope of the court's power under Section 39. Turning back to ground 2, I think I said yesterday that I had 8 supporting points in relation to the interpretation of Regulation 2A. Point 1, the PPA applied to any procurement contract of any public body, irrespective of the contract amount, save where exemption was specifically provided for in the Act or in the regulations made under it. You will recall that Section 3.2 of the PPA provided that the Act applied to any other procurement effected by a public body. Public body was defined in Section 2 and excluded at that point, at least at the initial stage of the promulgation of the Act, excluded an exempt organization. The language of any other procurement referred to any form of procurement other than the categories which are not relevant for present purposes identified in Section 3.1, which we can refer to as national security or defense procurement contracts. But the term procurement was otherwise very broadly defined as the acquisition by a public body by any contractual means of goods, works, consultant services, or other services. And a procurement contract was defined as a contract between a public body and a supplier, contractor, or consultant resulting from procurement proceedings. So the ambit of the PPA was very broad, applying to any procurement contract of a public body other than an exempt organization, save for national security and defense procurement contracts. The breadth of the PPA was further underlined by the specific provision in Section 3.4 that the Act shall bind the state. And importantly, the concepts of procurement and procurement contract were not defined by reference to any specific monetary threshold. Point 2, the PPA contained a set of provisions dealing with a special category of contracts defined as major contracts, which were identified by reference to the public body's contract types and contract amounts or contract amount thresholds identified in the schedule to the PPA. And the essential purpose and function of the schedule to the PPA was to identify the major contracts to which a special regime of procurement protection applied. So you will see the definition of a major contract at page 2601, and it may be worth turning it up. A major contract was defined as a contract for the procurement of goods or services or the execution of works to which a public body is or proposes to be a party, and the estimate of the fair and reasonable value of which exceeds the prescribed amount. Prescribed amount was defined on the same page as the amount specified in column 3 of the schedule corresponding to the public body specified in column 1 in relation to the type of contract specified in column 2 of that schedule. And if we turn to the schedule to the PPA as it stood prior to the July 2009 amendments, you can see the 3 columns identified in the definition. And you will note the reference to section 2 under the heading, under the schedule heading.
Could you remind me, Mr. Chuchoy, of the electronic page, please?
So this is page 2633, I believe. Does your lordship have that?
Yes, thank you.
So 2633, you can see the words section 2 in between brackets, which is a reference to where the schedule is referred to in the PPA, namely in the section 2 definition of prescribed amount for the purposes of identifying major contracts. The reference in the schedule to section 2 further underlined the relationship between the definition of major contracts through the concept of the prescribed amount and the schedule to the PPA. There was no separate definition of the schedule, but the definitions of major contract and prescribed amount provided the definition or described the function of the schedule. The conclusion that we say is plainly to be drawn from these provisions is that the essential function fulfilled by the schedule to the PPA was to define exhaustively the types of contract and the contract amounts in relation to the relevant public bodies that qualified as major contracts. That was a central purpose and function of the schedule to the PPA. It did not purport to be an exhaustive list of all procurement contracts that were covered by the PPA. Point 3, sections 8 to 14 of the PPA, which constituted part 3 of the PPA, contained a special regime of protection which covered the entire procurement process relating to the method of procurement, the award, and the conclusion of major contracts. And that special regime of protection was closely connected with the creation and operation of a central procurement board pursuant to the provisions of sections 8 to 14. I won't take you through those sections. You will have seen reference to those in our written submissions. And as regards major non-major contracts, the other provisions of the PPA would still apply to them as procurement contracts of public bodies pursuant to section 3.2. But the special regime in part 3 involving the CPB would not apply to such contracts. Point 4, prior to the promulgation of the PPR 2009 on the 29th of June 2009, the only exemption from the PPA related to the procurement contracts of ICAC. And save for the contracts of ICAC, any procurement contract of any public body, including any procurement contract of STC, was subject to the PPA. I've already referred to section 3.2. You will recall being shown the PPR 2008, when promulgated in January 2008. The reference is 2636. That's the beginning of the regulations. If you go to 2665, you will see the first schedule of PPR 2008 as created in January 2008, and that referred to ICAC as the only exemption. But save for that, all procurement contracts of all public bodies were subject to the PPA. And as regards STC, therefore, at that stage, all of its procurement contracts were subject to the PPA, and in addition, its major contracts were subject to the special regime in part 3 of the PPA. Point 5, The PPR 2009 introduced certain exemptions from the application of the PPA in the form of an amendment to Regulation 2 of the PPR 2008, the effect of which was to expand the exemption originally enjoyed by ICAC only to 6 additional public bodies, but in respect of, as regards those bodies, certain types of contract only, as described in the schedule to the PPR 2009, which you will find at pages 2672 and 2673. And as we know from 2672, the way in which the amendment was effected was first through Regulation 3 of the 2009 regulations, which effectively deleted and replaced the definition of exempt organization in the original 2008 regulations in the way indicated. And secondly, by replacing what used to be the first schedule to the 2008 regulations, which only referred to ICAC initially, with a new first schedule, which is set out on page 2673. Point 6, and this is the critical point, the purpose of Regulation 2A was to clarify the intended scope of the amendment to Regulation 2 by making it explicit that nothing in the 2008 regulations, which therefore would include any amendment to those regulations, was to exclude the application of the PPA to the procurement contracts of the specified public bodies, insofar as those contracts were specified in column 2 of the schedule to the PPA. And the critical point, we say, is that those words specified in column 2 of the schedule to the PPA are to be understood in context to be a reference to the major contracts of the relevant public bodies as specified in the schedule to the PPA. Now, in order to explain why I say that is the case, I need to develop the construction argument in more detail, and hopefully in the process also address Lord Hodges' initial question this morning. If one ignores Regulation 2A, it's fairly clear that the amended Regulation 2 and the schedule to the PPR would have exempted all of the contracts identified in the schedule to the 2009 regulation, irrespective of contract amount. So on that basis, even major contracts falling within the contract types described in the schedule would have been exempt from the application of the PPA. Regulation 2A, we say, qualified that position by making clear that nothing in the 2008 regulations could have the effect of exempting a public body referred to in the schedule, the 2009 schedule, in respect of a procurement contract to which the public body intends to be a party and which is specified in column 2 of the schedule to the Act. And the critical point we say here is that the procurement contracts specified in column 2 of the schedule to the PPA were only those contracts above the prescribed amount described in the schedule to the PPA. That was the function of the schedule to the PPA, to identify the contracts which were to constitute major contracts for the purposes of the legislation. And in context, therefore, yes, my Lord Lord Egger.
If the intention were to say that this doesn't apply to major contracts. It's an incredibly convoluted way of doing it, isn't it? When it doesn't even use the term major contracts or refer to the column in which the prescribed amounts for those contracts are set out. This would be an extraordinary piece of drafting.
Well, it's not. Well, let me put it this way: it's not as extraordinary as the piece of drafting that Betamax suggests Regulation 2A should be read as, and I'll come back to that in a moment. But let me just answer your point. It's not extraordinary if you look at it from the perspective of the draftsman knowing full well that the contracts that are the types of contract that are identified in the schedule intrinsically are contracts in relation to which there is a prescribed amount identified. It's very easy in my
but there's a defined term of major contracts. There's a defined term, major contracts, in the legislation.
But it would not if the draftsman had simply said the major contracts, that would, I mean, he could have said that. I accept he could have said it, but the question, in a sense, is this: you have a choice between two interpretations, both of which seek to give some meaning both to the exemption and to Regulation 2A. My construction seeks to give effect to both of those provisions as drafted, but simply construing the words that have actually been used in the context of what preceded the 2009 regulations. On the other hand, the Betamax interpretation doesn't try to give effect to both regulations as drafted. It seeks to rewrite Regulation 2A effectively to render it redundant and simply to be reasserting what is already stated in Regulation 2. That's the net effect of their construction.
Am I also right that your construction treats what's expressed as a saving clause, beginning nothing in these regulations shall be construed as excluding, as in fact removing an exemption partially in relation to ICAC, so that it in fact expands beyond what the scope of the legislation was before, whereas everything else, and the appearance of it, is creating more exemptions, but it does the opposite for ICAC. It creates less.
It doesn't. No, it doesn't, for two reasons. When the PPR, when the 2009 regulations were passed on the 29th of June 2009, ICAC was not referred to in the schedule to the PPA. If you look at page 2633 to 2635, which is how the schedule stood at that time, it did not identify ICAC, and it did not have the generic reference that only came a month later, parastatal bodies. That's the first point. And obviously, one has to construe the proper meaning of Regulation 2A as at the date when it was promulgated. But beyond that, in any event, even if one were to look at the position a month later, when after the Finance Act of the 30th of July 2009 had amended or had expanded part of the schedule to the PPA by the insertion of the generic reference to parastatal bodies, I don't accept that this amendment means that ICAC should from that point onwards be treated as referred to within the schedule for the purposes of Regulation 2A. Regulation 2A describes a public body referred to in the 2009 schedule and the schedule to the Act. That, in my respectful submission, properly construed, is a reference to the specific identification of the public body concerned. The relevant public bodies were specifically identified in the first schedule, and the meaning of referred to must be the same in both contexts, i.e. actually identified. So no anomaly or nonsense, as Mr. Howard puts it, is created by the construction that we put forward that seeks to give effect, fair effect, to both the amendment to Regulation 2 and Regulation 2A. So that is what we say in relation to the ICAC point. I'll come back in a moment, if I may, to the absence of an explicit reference to major contract or column 3. But I want to make clear first that the construction that we've advanced in our submissions is the construction that has been held by the Supreme Court. Mr. Howard yesterday gave the court a number of references to the judgment where the court simply used the formula contracts specified in column 2 to the schedule, specified in column 2 of the schedule to the PPA.
Mr. Chu Choi, I think Lord Burrows would like to ask a question.
I'm so sorry.
Yes, my question is simply this. As you put it, as I understand it, you are seeking to give some coherent meaning to Regulation 2A. Are you suggesting that if one rejects that construction, you might as well accept that 2A could just be excised? That, in other words, it has absolutely no point at all if Mr. Howard is correct. In other words, you're just left with Regulation 2 and Regulation 2A, you just excise. Is that your submission?
Absolutely. This is my point I was going to come on to, which is that Betamax's interpretation of Regulation 2A is not only based, we say, on a rewriting of the regulation, but actually, if correct, would mean that Regulation 2A is only stating the obvious and doing no work over and above, putting it, not a very sort of legalistic way of putting it, but it's performing no useful function other than to be reasserting what the principal provision is doing, which is the amendment to Regulation 2, which makes clear that the exemption that is being introduced is only in respect of contracts that are identified in the schedule, and that is a powerful factor militating against his construction. But I'll come back to that if I may. But can I just briefly explain the point that I was making a moment earlier, which is that what we suggest is the correct construction of Regulation 2A is indeed what the court has found. If I can ask you to look at page 227 to 8 of the judgment. If you pick it up on page 227, just below line 20, beginning, it has been seen that, to the end of that paragraph, and then over to the paragraph on the next page, you will see very clearly the court there saying, thus, any contract for acquisition by the STC of goods or other services for the prescribed amount of 100 million rupees or more would be excluded from the PP Regulations 2009 and would be subject to the PPA and its procurement process. If you go on to page 229, the middle paragraph, beginning the subject matter of the COA, line 3, as a result, goods would, for the purpose of column 2 of the schedule to the PPA, extend and apply in the present matter to a contract for the acquisition of freight which exceeds 100 million rupees. Page 230, the middle paragraph, beginning, in other words, the final sentence of that paragraph, the only condition being that the value of the contract must exceed 100 million rupees in respect of either goods or other services, respectively. Page 231, top of the page, beginning, as a result, by virtue of the clear provisions of Regulation 2A, the STC could not be an exempt organization, which would exclude the application of the PPA to the award of the COA. The parties were therefore legally bound to act in conformity with the requirements laid down in the PPA in respect of a procurement contract, which was of a type which fell under column 2 of the schedule to the PPA and which exceeded the prescribed amount of 100 million rupees. 234, two passages, top of the page, line 3, but the legislator, and this is after referring to Regulation 2A, but the legislator chose to leave Regulation 2A untouched. There the court is making the point that the language of Regulation 2A was not changed either with or after the passing of the Finance Act of the 30th of July 2009. That's not an insignificant, that's a significant point as well for a different purpose, but I'll come back to that. But there again, you can see the court saying that the legislator chose to leave the regulation untouched, so that Regulation 2A continued en toute connaissance de cause to apply to any column 2 contract for the prescribed amount. And then the passage just above line 20, the paragraph beginning, if the answer is in the affirmative, that is the end of the matter, as the PPA and its procurement process applies to the contract. The PP Regulations 2009 and its provisions with regard to exempt organizations are purely and simply excluded by the operation of Regulation 2A, where the contract falls within column 2 and meets the prescribed amount.
Mr. Chuchoy, as I indicated at the outset, I don't think the board has any difficulty in recognizing that the Supreme Court did refer repeatedly to the prescribed amount. Where I'm looking for help is, where did they explain why the reference to column 2 brought in the prescribed amount?
Yes, well, I don't believe that they specifically address that issue, save by reference, obviously, to the schedule to the PPA and the fact that you only get column 2 and the prescribed amount in the schedule to the PPA. But the points I want to make are that hopefully will assist the court on this aspect are these. The legislator must be presumed to have been aware of the status and function of the schedule to the PPA as a list of major contracts covered by the special regime in Part 3. If the intention was, as is Betamax's case, for the legislator to refer to any procurement contract that was not referred to in the 2009 schedule itself, why was it necessary to refer to the schedule to the PPA at all? Why? Why did Regulation 2A not simply say, nothing in these regulations shall be construed as excluding blah, 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 and then instead of saying, and which is specified in column 2 of the schedule to the Act, it simply said, and which is not referred to in the schedule to the 2009 regulations. That, they say, is the right construction. Well, if that was the only category, that was the only category in respect of which they needed to make clear the exemption applied. Well, why not say that? Why express the carve out by reference to the schedule to the PPA? And yes, I agree, therefore, it doesn't refer to column 3, but incidentally, it doesn't either refer to column 1. But nobody doubts that it's referring to the relevant public bodies. And when you consider the definitions of major contract and prescribed amount, which are the quasi-definitions for the schedule, in my respectful submission, it's not that surprising that the draftsman, as a shorthand, because he was focusing in particular on the nature of the types of contract, simply put it in terms of the contracts referred to in column 2 in the schedule, without articulating also that he is referring to the contracts of that type, the only contracts of that type that are referred to in the schedule, which are contracts for the prescribed amount. And again, if you look at the layout, I invite you again to look at the layout of the schedule to the PPA. It may be worth bringing that up. 2634, 2635. The contract amount, very important to look, just visually look at that, because one imagines that the draftsman would have had this picture in his or her mind when using that formulation. When you look at the layout, the contract amounts appear as an integral part of the description of the contracts in column 2. The contracts in column 2 do not have an existence that is independent of the contract amount. They never have, because the only significance of the articulation of those contracts in that schedule was for the purposes of identifying major contracts. There was otherwise no reason at all for the creation of a schedule to the PPA, because under section 3.2 and under the very wide definitions of procurement and procurement contract, the Act applied to every procurement contract. So, my Lord, forgive me.
Can I just be clear that I understand the submission? I think it's been put to you that the reference to column 2 should, on your interpretation, have also included a reference to column 3.
Yes.
Now, as I understand your submission, you're saying that the whole context and the whole point of the schedule was always to run together column 2 and column 3, because they're only there as definitions of main contract, and they are never decoupled.
Never.
There's no circumstances in which you would ever decouple column 2 and column 3. So the reference to column 2, as I understand your submission, automatically must take with it column 3. There's no other purpose or context to it. Is that correct?
Absolutely. And moreover, my point is simply that I say is essentially what the draftsman assumed, because there was no other function that the schedule to the PPA was performing. In fact, if you look at where the schedule to the PPA is referred to in the PPA, it is essentially only in the definitions of prescribed amount and major contract. It fulfills no other purpose, and column 2 fulfills no other purpose than in conjunction with column 3. And of course, I accept that point has to be considered in the context of the competing argument that my learned friends advance. This is the so-called what one may, as a shorthand, refer to as the foreclosure point. That they say, well, because of the way in which exemptions were originally expressed by reference to a public body as a whole, there was a risk that once a public body was identified in the 2009 schedule, that would automatically mean that therefore all of that body's contracts would be exempted, and Regulation 2A was an attempt to avert that risk. And I just want to subject that suggested rationale to some close analysis. First of all, there is very serious reason to doubt that the legislator was in any way alive to this risk, which it has taken Betamax, I think, 4 years to come up with, to identify. Shortly after the 2009, because obviously the court has to consider the proper construction, and points that, well, arguments have not been thought of before can only go so far. If an argument is correct, it's correct, even though it's very late. But the fact that it has taken them so long to work it out, to suggest that it was something that was readily apparent to the draftsman, that is what he was thinking of when he was drafting Regulation 2A. That takes a bit of gulp in my respectful submission. But let's look at it closely. Within a month of the 2009 regulations, when the Finance Act was passed, pursuant to Section 35B2 that you've seen already, Section 3.2 was amended, and we see that at page 2738. And you can and you may recall that Section 3.2 was amended. We might be able to pick it up quickly in the supplemental bundle, where the consolidated regulation, consolidated act appears, which is on page, forgive me, on page 19. So a month after the 2009 regulations are enacted, the legislator, who is to be presumed to be all-knowing and all-present, as it were, or at least all-knowing so far as the PP legislation is concerned, amended Section 3.2 to provide this act applies to any other procurement effected by a public body other than an exempt organization. Now, on its plain wording, this amendment, a pointed amendment that the legislator is making at about the same time, is perpetuating the notion of exemption by reference to a public body as a whole. My learned friend made much of the point that the definition of public body was amended, the deletion of the exclusion of exempt organization from that definition. That is true, but there's nothing in that point, because what the legislator did was to remove that element from the definition, but then to put it in the central provision that deals with the ambit of the act. And so the obvious point that arises is, well, if the legislator was so alive to the risk adverted to by my learned friends, and that was the reason why Regulation 2A was inserted, why did the legislator continue to adhere to that concept? Would it not have been much easier? Forgive me, my Lord Legate, may I just finish that sentence and then I'll come to you. Would it not have been much easier for the legislator to get rid altogether of the concept of exempt organization, and to express the notion of exemption by reference to the particular contracts of bodies that have been identified in regulation? But he didn't do that. He or she didn't do that. My Lord Legate.
This goes to some arguments made by Mr. Howard as well as you, but is it in principle right that we should be construing the legislation by reference to subsequent legislation.
Well, that's a very difficult proposition in my respectful submission. That one is to treat this legislation in the light of. I suppose Mr. Howard would. Well, it's not clear to me, in fact, what Mr. Howard is saying on this point. I think I assume that the minimum he would say is that, well, I should be able to take into account amendments that were enacted right up until the date of the COA. But some of his submissions relied on amendments made long after that.
Well, I know, that's why I said it goes to him, but at the moment you're developing such a point, so I thought I'd just raise now whether it's sort of point that's appropriate for either side to make.
Well, but my point is, but it's appropriate in my case for this reason, that he is saying that as at 29th of June 2009, the legislator had that risk in mind. Well, fine, but that then presupposes that only a month later, the legislator had apparently forgotten about it. Well, how can that be? How credible is that? How credible is that?
Well, if the legislature were a person, that might be a good argument, but
it's not. The legislator, for this purpose, we know, is the virtual, legal representative or person.
Exactly, whose intentions we construe objectively, not by reference to subsequent events, I don't think.
Correct. But I don't need. I simply rely on the subsequent event to show the implausibility of the suggestion. But I'm perfectly content. I'm perfectly content to make the same point good by reference to the continuing existence, as at the 29th of June 2009, in the Act itself, of the notion of public body other than an exempt organization. That's good enough for me.
Okay.
So, my lords and my lady, the supposed risk identified by Betamax, we say, sorry, just moving to a different point. So I've already, my first point is there's very serious reason to doubt this supposed aliveness to the risk referred to by my learned friends. The second point is the supposed risk anyway could have been simply identified, as I said earlier, by using the word "and which is not referred to" in the first schedule, instead of the rather more elaborate reference to contracts specified in column 2 of the schedule to the PPA. And we say it's simply not credible that the legislator should have felt it necessary to refer to a schedule that only dealt with major contracts if its intention was merely to clarify that all procurement contracts other than those referred to in the schedule should remain subject to the PPA. And that's the point that Betamax makes as the reason why the Regulation 2A was necessary. That's not what Regulation 2A says. And so the Betamax construction therefore boils down to this. It requires you to accept that the legislator made a loose and inaccurate reference to contracts specified in column 2 of the schedule to the PPA, when its actual intention was to refer to all procurement contracts other than those referred to in the 2009 schedule. And that is simply not plausible in my submission. My Lord Woodagger.
Surely the suggestion is that what it's seeking to do is not to refer to all contracts made by those public bodies listed in column 1, but just to make sure that contracts which appear in column 2, but which aren't of the exempted type in the regulations, remain covered.
Yes, that is what is being suggested, but it doesn't make sense because the risk that's identified, which it is said had to be catered for by the introduction of Regulation 2A, was a risk that procurement contracts, any procurement contract, other than those specifically identified in the 2009 schedule might otherwise be said to be exempted because they were a procurement contract proposed to be entered into by the public body. But the schedule is not and was never conceived of as a schedule of all procurement contracts. It was only ever conceived of and applied and used as a schedule identifying major contracts. So having therefore identified what seemed like what they thought was a good rationale for Regulation 2A, when you carry through the logic of the reasoning, it doesn't work out. Moreover, how does the actual language of Regulation 2A supposedly foreclose the risk that they identified on its face? Well, it doesn't. Because Regulation 2A, on its plain wording, makes clear that the PPA would continue to apply to procurement contracts specified in the schedule to the PPA, even if referred to in the schedule to the 2009 schedule, sorry, to the 2009 regulations. Regulation 2A only works and only forecloses the argument they identified if it's rewritten so as to conform to their interpretation. In other words, if you add the words at the end that don't appear, and which is not, and which are not identified in the schedule to the 2009 regulation, it's only if you add those words that Regulation 2A then arguably achieves the purpose or addresses the risk that they've identified. It still doesn't totally, because it's referring to the schedule to the PPA, which we know is not a schedule of all the procurement contracts. But even if you ignore that and you kind of give them the benefit of the doubt in that respect, it still doesn't work and doesn't address the risk they identify unless you add those words. But if you add those words, then all that's being achieved is that the foreclosure argument, or rather all that shows that the foreclosure argument assumes the correctness of their interpretation, but it doesn't independently prove it. You can only make the clause do what they say it does by adding the words that they would like to add to it. But the reason they give doesn't explain why those words should be added. It doesn't. And if it did, it would do so in a wholly imperfect manner by a reference to a schedule that is not a schedule of all procurement contracts. And we say that in reality, if the foreclosure point played any part in the legislator's thinking, the language that foreclosed the risk was not the language of 2A, but the language of the amendment to Regulation 2 itself. Because it is that amendment that said in terms that the exemption would only be in relation to the contract specified in the schedule to the 2009 regulations. So those really are my key submissions on that central point. And we say that, of course, if we're right in that construction, there is no case of entire negation or annihilation, obviously a word that my learned friends like to pick from the judgment because it allows them to say, oh, well, that means that the Supreme Court's interpretation of 2A completely nullifies the amendment to Regulation 2. Well, we know from the Supreme Court's own judgment that it doesn't do that anyway. We say that the plain and ordinary meaning of Regulation 2A as applied by the, or as found by the Supreme Court, supported by the contextual considerations, is an entirely plausible and sensible construction. And moreover, it was a rational result for the legislator to have wanted to achieve, because as we saw, the original position prior to the introduction of the 2009 regulations was that only ICAC was exempt. STC wasn't exempt in any respect. And the exemption regime introduced by the 2009 regulations was plainly intended to be relatively limited. It applied to only 6 additional bodies. And even in relation to those bodies, it only applied to certain types of contracts. And in the context of what was intended to be a limited exemption, it would not have been surprising, in our respectful submission, for the legislator to have intended that the exemption should not extend to the relevant public body's major contract, as referred to in the schedule to the PPA. The major contract benefited from important additional safeguards, and it's readily understandable that the exemption should not have been thought appropriate in relation to such substantial contracts. And the amounts, incidentally, are, in the Mauritian context, substantial. A contract for £2 million is a lot of money in Mauritius.
I take it, Mr. Chuchoy, that by the nature of parties' representations, that no one was able to find any authoritative statement anywhere about the policy behind the changes made in July 2009.
I don't believe so, my lord. No.
Yes, I think Lady Arden was wanting to ask a question. I don't know if she still is.
I do. It's a very basic question. I'd just be awfully grateful to have this cleared out of the way. When 2A starts nothing in these regulations, what particularly are you saying is the something in the regulations that is being counted?
It's essentially everything in the regulations. So what is meant by nothing in these regulations is nothing that may be set out in these regulations, which is the 2008 regulations, which will have been amended, it is to be construed as set out in Regulation 2A. You will recall 2009 regulations do 2 things. They amend Regulation 2 of the 2008 regulations, and conscious of that amendment, the draftsman and the wording of the regulations of Regulation 2A as well is no coincidence. Regulation 2A comes straight after Regulation 2, which is the very provision that is being amended by the draftsman. So the very ordering of the regulation, one might think, is indicating that the draftsman was seeking to address the scope of the exemption in the schedule, and so I don't know whether I've answered your question, my lady.
Well, thank you. It is a convoluted way of saying these regulations do not apply.
Well, it's not that. Well, the purpose of 2A is not saying that the regulations do not apply. It's seeking to, as I think is common ground, it seeks to save the operation of the Act in certain circumstances. And what it does is to identify, granted the regime of exemption that would otherwise exist under the regulations, it's clarifying precisely what is or isn't exempted under the PPA and under the legislation.
Thank you, Mr. Chuchoy. You will bear in mind that the 5-minute adjournment mid-morning. I think you're about to move on to another topic. Am I right?
Yes, I think perhaps I can, now would be a convenient moment.
Thank you very much. The court will adjourn for 5 minutes. We're ready to resume. I think Lady Arden has a question to ask.
Thank you so much. Could I just complete the question? when you get to section regulation 2A, and I'm looking at page 2672, when it says nothing in these regulations shall be construed as excluding the application of the Act, is it not possible that the provision of the Act which is being referred to is the new definition of exempt organisation, or are you saying that simply into the regulations has no effect on the Act?
Well, it wasn't it can't have been a reference to the new definition of public body in the Act, because at that point the definition of public body had not been amended. Was that the premise of your question?
And so the definition in the Act remains, just remind me.
Remained that a public body excludes an exempt organisation.
Yes, so the effect of that is intended to, it is that the body becomes wholly exempt, even in respect of any of its contracts.
Well, not in the light of Regulation 2, which makes clear that an exempt organisation means a public body which is excluded. If you look at Regulation 3 above, by which the amendment was introduced to the definition of exempt organisation, that made clear that an exempt organisation means a public body which is excluded from the application of the Act in relation to contracts referred to in the first schedule.
Well, but maybe what the draftsman of 2A had, drafter, pardon me, of 2A had in mind was that having remodeled the definition of exempt organisation, he didn't wish to throw any doubt on the definition for the purposes of the PPA.
It would have been a very curious way to do it by reference again to contracts referred to in the schedule to the PPA. I mean, that doesn't really address that point for the reasons that I explained earlier.
Well, that by then has been inserted. The schedule has been inserted. That very well. Let's go on to the next point, and perhaps I could come back to this.
Right. So the next point I want to complete on the ground too, which, and I will do that at some speed if I may, which is that, well, even if the Supreme Court was wrong about 2A, we say in any event the COA does not fall within the schedule to the 2009 regulations because the COA was not a contract for the purchase of goods for resale. It's common ground that the COA itself is not such a contract. The question is whether merely because the products that were shipped on Betamax's tanker pursuant to the COA were in fact purchased by STC for resale, does that bring the COA within the language of the schedule? Now we say that that fact does not bring the COA within the language of the schedule, because on the proper construction of the schedule, it's plain that the relevant goods must be purchased for resale under the contract which is claimed to be exempt under the schedule, not under some other contract, here the contract or contracts between STC and the third-party seller or sellers of the petroleum products. In other words, the 2009 schedule describes the types of contracts exempted, and it is those contracts, therefore, that must meet the description in the schedule. So relying, therefore, on the subject matter of other contracts pursuant to which the purchase is done of the goods for resale is not, in my respectful submission, a tenable way of trying to force the COA into the description of the schedule. I'm referring to the mere fact that the products were purchased by STC for resale. Of course, there is a separate point that the other side rely on, which is that, well, the freight services provided under the COA were services that were incidental to the supply of petroleum products to STC and were covered by the broad definition of goods. Well, it's perfectly true that goods is very broadly defined as a term, but the term goods does not appear in the schedule for the 2009 PPR in isolation. The term appears in conjunction with the term for resale. The subject matter of the exemption is not merely goods, unlike, for example, in the case of the Mauritian Examination Syndicate, further down the page, but goods purchased for resale. And in my submission, by that composite expression, the legislator was clearly aiming at a specific type of contract, where the subject matter of the contract is purchase for resale. So, for example, therefore, if STC contracted to purchase building materials to build its own storage tank or a grain warehouse for its own purposes, or if it purchased furniture or other goods for the use of its own staff, such a contract could not possibly be for goods purchased for resale. And such a contract would not fall within the exemption. The fact that the goods in question might be indisputably covered by the definition of goods would not be sufficient to engage the exemption. Likewise, therefore, or by extension of that reasoning, the fact that services might be included as well under the contract could not make any difference, because the subject matter is not acquired pursuant to the contract for resale. Now, Betamax refers to the fact that the Supreme Court relied on the broad definition of goods when looking at the schedule to the PPA, but you've got, and we address that point fully in paragraph 86. In fact, given the time that I have left, I'm going to skip over that. Please, on that point, please look at paragraph 86 of my written case, where we make the distinction that when applying the broad definition of goods, the Supreme Court was addressing the question of the construction of the schedule to the PPA, where the reference was simply to goods, not goods purchased for resale. The final point, Lord Leggett.
Do you offer any rationale for the exemption on your interpretation? Is there any good reason to?
I do. I have an explanation. Whether it's good, whether you consider it to be satisfactory, will remain to be seen. But let me just tell you what it is. This is where the focus turns not to goods purchased for resale, but to the inclusionary words at the end of that expression. Now, the subject matter of the PPA regime as a whole, including the scheme of exemption, is concerned obviously with the award of procurement contracts. And the amendment to Regulation 2 was formulated by reference to contracts referred to in the first schedule. And the types of contract that would be exempt were identified in the schedule under the heading type of contract. And the words goods purchased for resale appeared under the heading of type of contract. So the application of the exemption requires the contract to be the type of contract that is specified in the exempting provision. Now, the phrase including services incidental to the purchase or distribution of the goods, in my respectful submission, is dealing with a situation where the putative contract includes services incidental to the purchase or distribution of the goods for resale, which services would not themselves be for resale, but which the drafter wants to make clear is to be treated as encompassed by the exemption, because the contract is of the right type, i.e. a contract concerning goods purchased for resale. we say that's the combined effect of the incorporation of the words including as well as such goods at the end of the description, i.e. the goods for resale. And contrary to what Betamax contends for, it would not be appropriate to treat the inclusionary words as themselves constituting an entirely separate category of exempted contract.
Mr. Tutoy, with respect, the question Lord Leggett was asking was not how do you parse the provision, but what's its rationale?
Yes.
I wonder if you could assist us on that.
Yes. So the rationale is this, that a contract for goods purchased otherwise than for resale is plainly not intended to be covered by the exemption. That is so whether the subject matter of the contract is primary goods or incidental services. So the default position is that a contract for either primary goods or incidental services for the public body's own use or consumption was never intended to be covered by the exemption. That's the starting point. The words including services, etc., enlarge the exemption, or at least clarify the scope of the exemption by making it clear that the putative contract remains exempted, even if it is a contract for goods purchased for resale, if it includes, and even if it includes incidental services that may not themselves be for resale. So that in my respectful submission is the proper scheme of the exemption. And I agree and I accept that in the light of that, one could question why the legislator singled out goods purchased for resale for exemption, but not goods for the public body's own consumption. Why the exemption did not extend to other types of contracts. One could speculate, and I don't have an answer. I don't know. Why is it that goods that are simply purchased for one's own consumption should not be the subject of an exemption? No idea.
Thank you.
But the point is this: the mere fact that you can't give an answer for why particular wording might be there does not mean that you ignore the structure of the language as a whole. And once you realize that the default position is, as I've explained, and the inclusionary words essentially expand on that position, there's no anomaly. And yes, it does mean that some contracts ultimately may end up not being covered, but that's simply because the regime of exemption is limited and incremental. Ground 3, if I may. We'll have to go through that at rather great speed, but obviously it's a very important ground, and I do want to make sure that I cover the important point. Point 1, the question of criminality. I'll deal with that very briefly because it's a bit of a red herring in my submission. Notwithstanding the isolated reference to the commission of criminal offences at paragraph 110 of the STC affidavit that you were shown yesterday, our submissions to the Supreme Court were not founded on any allegation of criminality or deliberate breach of the PPA. We relied on the fact of breach of section 14 of the PPA as constituting a violation of public policy that was sufficiently serious for the purposes of the public policy exemption. This was well understood by Betamax, who did not seek or need to rebut or counter any allegations of criminality in the Supreme Court proceedings. And that's very clear from the written submissions of STC, and I'll give you the references. STC opening submissions, paragraphs 132 to 138, pages 2476 to 2480. Betamax opening submissions, paragraphs 114 to 124, pages 2514 to 2516. STC reply submissions, paragraphs 56 to 59, pages 2578 to 2579. and the Betamax reply submissions, paragraphs 31, 32, and 34, pages 2592 to 2594. The passage in the judgment of the Supreme Court, where the judges referred to section 60 of the PPA, which identifies the criminal sanctions for breach of the legislation, was simply a recitation of the section as part of the Supreme Court's assessment of the and ultimate characterization of the act as a whole. It was not a recitation with respect to any judgment or decision as to criminality or otherwise. But absence of criminality on the facts is not determinative of, nor even relevant to, the two critical issues of nullity under the PPA, or alternatively, nullity under the general law. And I deal with nullity under the PPA first. Our argument of nullity under the PPA is founded on the special provisions dealing with major contracts. And the points of these, major contracts, as you know, were subject to the special regime. I ask you to consider sections 8 to 14 in their entirety, but I want to emphasize in particular the following. No CEO of a public body could enter into a major contract without informing the CPB in writing and submitting all relevant documents to it. 2, only the CPB could authorize the public body to call for bids or to use some other appropriate procurement method. It was the CPB's responsibility and authority to approve the award of every major contract. There was an express prohibition in section 14, subsection 4A, against any public body either advertising for, inviting, soliciting, or calling for bids in respect of a major contract, unless authorized to do so by the CPB. There was an express prohibition in section 14, subsection 4B, against any public body awarding a major contract, unless the award had been approved by the CPB. And last but not least, there was an express prohibition in section 14.5 against any person, including therefore any would-be contractor or supplier to the public body, signing a major contract with a public body unless the award had been approved by the CPB. So section 14 therefore contained a series of prohibitions, absent relevant approvals from the CPB, in relation to the entire process, whereby a public body might solicit bids for or commence a procurement process or award or conclude a major contract. And it further prohibited any potential third party who might want to contract on major contract terms. The section was clearly aimed, therefore, at preventing the creation of any contractual relationship between a public body and any other person on terms that qualified as a major contract, unless the relevant approvals from the CPB had been obtained at every described level. Given the nature of these prohibitions, their logical implication is that if a major contract is entered into in violation of the prohibitions, the contract is not intended to be effective, because were it otherwise, the legislative aim that is apparent on the face of all of those prohibitions would be frustrated. The absence of an express nullity provision in the PPA does not preclude the implication that I've just described, nor does it militate against it. The prohibitions themselves against contracting are explicit, and their underlying intention, namely that there should be no contractual relationship, i.e. no legal relationship on the terms of the contract, is clear. There must be no major contract entered into without the relevant approvals. And this argument of implied nullity in my submission is supported by the nature of the prohibitions and is consistent with their plain legislative aim. And although Betamax is correct in submitting that the Act as a whole applies to all procurement contracts, including major contracts, importantly, the Section 14 prohibitions are unique to major contracts. There are no equivalent prohibitions in respect of the conclusion of procurement contracts in respect of non-major contracts. None of the challenge and appeal provisions relied upon by Betamax in sections 40, 43, and 45 detract from the existence or the application of the Section 14 prohibitions. The prohibitions are there, nor do they address the consequences of a violation of those prohibitions. The most that those challenge and appeal provisions indicate is that not all breaches of the PPA will necessarily prevent a legally binding contract from being concluded. And I accept that. The procurement process, for example, might involve sending 15 forms rather than 12. A bidder might breach the rules by sending only 10. Nobody's suggesting that every single breach of every single procurement requirement will result in the nullity of the contract. That's not the debate. The debate here is about the consequences of a violation of direct prohibitions on contracting. And that regime of prohibition is unique to major contracts. And this is what also distinguishes in a fundamental way the PPA from the UN procurement model law, because that model law has no equivalent to Section 14 and its prohibition. And the answer, therefore, to the question of the consequences of a breach of those prohibitions is not to be found in the model law or in a comparison with its boilerplate between the PPA and its boilerplate provisions. So that's nullity under the PPA. Nullity under Articles 1131 and 1133. And this is in the alternative to nullity under the PPA, and it is a true alternative in my submission, in the sense that even if the PPA on its own terms and on its own construction, whether expressly, well, we know it doesn't contain an express provision, even if on its proper construction by implication, it does not provide for the nullity of the contract entered into in breach of Section 14. The civil code ground of nullity under Articles 1131 and 1133 are engaged. You will recall from the supplemental bundle, page 7, that Article 1131 says that an obligation without a cause or with a false cause or with an illicit cause cannot have any effect. And then 1133 says a cause is illicit when it is prohibited by law, when it is contrary to bonus mores or to public policy. And the two elements that we're concerned with here are prohibited by law or contrary to public policy. In the context of Article 1133, the general distinction that was drawn yesterday between objective cause and subjective cause is not in dispute, nor is STC contending on this appeal that the COA was entered into for a subjective, unlawful purpose. But the critical question is how to apply the concept of objective cause in the context of the Section 14 prohibitions. And as to this, there are 6 points. First, as the Dalloz extract at page 4400 explains, it may be worth that being brought up. You're looking at that very briefly. 440, this was the passage that was shown to your Lordship Mr. Moulin yesterday. That explains that if you look at the underlined bit, according to a first method, which is referred to as objective, the judge would focus on the exchange and carry out an objective examination thereof. He would capture the elements of the bargain, the counterpart, as they appear. So as that indicates, the objective clause is concerned with the objective elements of the bargain, i.e. the terms of the contract as agreed between the parties. As seen earlier, in the absence of the relevant approvals from the CPB, the effect of section 14 is to prohibit the conclusion of the contract itself. So what is the subject of the legal prohibition under section 14 is the contract itself, i.e. the objective clause, the objective elements of the bargain. That's what is prohibited. So the section 14 prohibitions, therefore, are not concerned with the party's subjective motive. It's fundamentally concerned with the prohibition of contracting and therefore of the objective cause of the bargain between the parties. And that being so, we do say, therefore, that because the subject of the prohibition under section 14 is the contract itself, it can properly be described as a prohibition of law or a prohibition by law of the cause for the purposes of Article 1133. And on this basis, contracts entered into in breach of the section 14 prohibitions are properly to be seen as an illicit cause within the meaning of Article 1133. The present case is very similar to Uteam and Monique, which my learned friend referred to, which we've relied on in our submissions, where the transfer of a bus license was specifically prohibited. Perhaps we ought to get the case up. It's very short and it's got some critical paragraphs. 3701. That was a case where the transfer of a bus license was specifically prohibited by the relevant legislation, and a transfer in breach of the prohibition meant that the transfer was legally ineffective. Now, contrary to what Mr. Moulan appears to have argued yesterday, there is no relevant distinction to be drawn in this context between a statutory provision that prohibits a transaction in all circumstances and one which prohibits it in some circumstances only. For example, when required approvals have not been obtained. When in given circumstances, the prohibition against the relevant contract is engaged, there is a prohibition by law within the meaning of Article 1133. And that is what matters for the purposes of Article 1133.
Yes. Could you very kindly just pinpoint the wording in section 14 on which you rely, because there's no equivalent to UTeam. It doesn't say a legal person is not capable of becoming a party to a contract which has been executed in violation of the regulations. Does it deal with the effect if a person does become a party? Does regulation 14 deal, or section 14, sorry, deal with that?
No, section 14 does not. Section 14 in terms does not address the question, what happens if a contract has been entered into in violation of its terms? I accept that. There is no, as the other side said, there's no express nullity provision or no express consideration of that situation. But what is very clear is that it prohibits the conclusion of the relevant contract unless the relevant approvals have been obtained. And there is, therefore, a clear analogy between section 14 and the provision that was under consideration in UTeam that you see on page 3702.
Mm-hmm.
The basic facts of that case were that there was a claim for damages advanced, the validity of which depended upon whether a bus license had properly and lawfully been transferred to the claimant's to the claimant, the relevant legislation said on page 3702 that a license granted under this part shall, except with the prior approval of the authority and subject to regulations made under this act, not be capable of being transferred or assigned.
Well, there's no analogue in section 14. It doesn't say a person is not capable of becoming a party. It just says he shall not do so.
But with respect, Section 93 of that legislation is addressing the question whether you can enter into a lawful transfer or a contractual transfer of a license. It's saying you're not able, you're not capable, i.e. you're not allowed to enter into a contract for transferring the license. We know the license exists. The issue is not about the license. The issue is about the contract to transfer it. That is the subject of the prohibition in Section 93.
That's another difference between there and Section 14.
Well, no, my point is that that's not a difference, because Section 93 does not seek to invalidate the license when it's being transferred. What it is saying is, if you seek to transfer it, that's not effective. So it's saying you can't do that unless you have the relevant approvals. In other words, you can't enter into a valid contract to transfer the license unless the relevant approvals have been obtained.
Mr. Chuchoy, you are running out of time, so I have to invite you to sum up now.
Yes. So what I say is that case, and I invite you to read that case. And interestingly, in that case, Judge Conay, who was the judge in that case, is also was the senior puisne judge in our case. But we do say that that case is very close to our case. We say that in addition to the prohibition by law element in Article 1133, we can also rely on the contrary to public policy element. We rely on the Court of Appeals, the Supreme Court's reasoning on the status of the statute, and I commend to you the analysis from pages 237 onwards, and I ask you to, in answer to, I think, two of the judges' question about what is the criterion that we should apply to determine whether the relevant statute qualifies as public policy for the purposes of Section 39. Well, look at the test that the Supreme Court concluded upon at page 245 of the judgment after a detailed review of the relevant case law.
Mr. Chuchoy, you will now have just to adopt your written submissions because you are out of time.
My lord, can I just make one point, if I may, give you one reference?
Yes.
In relation to the point that my learned friend, the distinction my learned friend drew between relative nullity, nullité relative, and absolute nullity. And the point is simply that if you look at the Dalloz articles or translations at pages 127 and 129, you will see that the consequence is absolute nullity rather than voidability when the cause is illicit within the meaning of Article 1133. And if the cause is illicit, you can't, by repackaging it, as it were, by saying that the problem is about the formation of the contract, try to bring it within the scope of Articles 1109 and 1117.
Mr. Chuchoy, we will look at that provision, but I have to stop you at this point. Thank you very much indeed. Mr. Howard.
Well, my lady, to answer the question, why is this an international arbitration under the Act? It's because the seat of the arbitration is in Singapore. See the International Arbitration Act at page 3833 of the bundle, which defines an international arbitration as including one where the juridical seat of the arbitration is outside Mauritius. Now, leaving that on one side, the starting point is that the court under section 39(2)(b)(2) can only intervene where the award is in conflict with public policy. That is critical. The court starts with the award. The question is whether that award is contrary to public policy. Now, the reason it is important to distinguish between the award and the contract is because where illegality, for instance, as with any other argument, but illegality of the contract is put before the arbitrator and fairly and squarely decided by the tribunal acting within the scope of its jurisdiction, the fundamental starting point under the Mauritian Act, as indeed in common with all other international modern arbitration jurisdictions, is that the supervisory court should respect a decision taken on the merits by the arbitrator, save in very limited circumstances. And that approach is consistent with the principles underpinning the legislation, firstly, respecting the important public policy of finality, respecting the principle of non-intervention, and the limited recourse to public policy rightly described by Sir John Donaldson in the Deutsche Schachtbau case as being a concept that should be approached with extreme caution. And if the intention of Parliament had been to allow decisions on the merits to be reopened by a local court, then they would provide a general mechanism for appeals on errors of law, which has not been done. And so in our submission, the STC's submissions betray a misunderstanding of the role of Section 39 generally and 39(2)(b)(2) in particular. The existence of the relevant subsection is not meant to provide a license to review awards extensively. It provides a long stop and narrow control of compliance of the award with the public policy of the forum in circumstances where the dispute has been heard and determined in accordance with the parties' agreement. The role of the court is not to strive to find a basis on which to annul an award or to interfere with an award, quite the opposite. The court starts from the premise that matters falling within the jurisdiction of the arbitrator are binding. Now, if the arbitrator has made findings of unlawful conduct or which engage public policy, or on the findings the conduct would engage public policy, then we accept at that stage the court is entitled to consider the position. Indeed, the only case that anybody can refer to where this has been done is, of course, Soleimani, where the Beth Din had found that the contract was a smuggling contract. But because under Jewish law, that was, as it were, nihil, nothing to consider, the court, the English court, when enforcing, had to consider its public policy. Will we enforce an award which is in respect of a contract which has been found to be a smuggling contract? Answer, no. Now, ST's approach is not only contrary to the fundamental principles and policy of the Act, it would also be, firstly, completely uncertain in that one would have no relevant criteria by which one could properly determine when one was going to take this approach, and it's unsupported by authority. Taking first the uncertainty, let's see where we've got to. ST accepts, firstly, that errors of fact cannot be challenged. Secondly, questions of law, where the applicable law is other than here Mauritian law, those can't be challenged. Thirdly, questions of law which involve contractual interpretation, those can't be challenged. Fourthly, they say, questions of law involving statutory interpretation cannot be challenged where the statute does not implicate public policy, but, they say, questions of statutory construction under Mauritian law can be challenged where the statute is said, apparently by the local court, to embody important public policy. Now here, one is actually left with the feeling, because the financial consequences of having repudiated the COA were significant for the Mauritian state, that somehow gave the court the right to interfere. But one should ask, as a matter of principle at this stage, or as a question, what is the sensible guiding principle or rationale which STC has identified which supports this approach? And we say that there is none. And the relevant distinction is not between questions of fact or law and questions of law involving questions of statutory construction. The critical question is rather different, and it's a question as to whether, in the light of the findings that the tribunal has made on matters that fall within its jurisdiction, public policy is involved. But just before considering that, firstly, I ask you to consider, why should it be the case on STC's case that questions of fact cannot be challenged, whereas certain questions of statutory construction can be? So if there's a question of fact as to whether a contract was a major contract rather than a minor contract, they say that can't be challenged, but the public policy point would be exactly the same. Equally, one can think about questions of bribery. Now, what we have repeatedly said in the by STC is it's all to be determined by what they call the nature and scope of the public policy at stake. But that, with respect, provides no assistance whatsoever. And let's approach it by considering a question that my Lord Hodge asked, which is, well, how do you tell whether the statute is one that engages the public policy? And the first answer to that is that before one considers what my learned friend had to say, is that most statutes, if not all statutes, but certainly most, reflect the public policy of the state. Now, the answer that Mr. Chu Choi gave was in fact rather circular. He said the statute had to reflect a sufficiently fundamental norm of that jurisdiction. Now, we would say that that is not a criterion, or at least not a sensible criterion for intervention. But secondly, even if it was, it would simply open up to the supervisory court to review any case involving a breach, any award which involved a determination as to whether a statute had been breached, because it would be able to characterize the legislation as sufficiently fundamental. And as I say, it's difficult to see, in fact, how a statute, and practically any statute, doesn't fall within that example. And it's interesting to note the example that STC purports to give at footnote 44 of its written case concerning drainage pipes. And it suggests that a building contractor breaching statutory regulations about the size of drainage pipes in the construction of a building would be unlikely to face an argument of public policy. Now, actually, that's a self-defeating point. The size of drainage pipes are obviously a matter of important public policy, determining how rainwater or wastewater is run away. In this jurisdiction, just think about building regulations relating to cladding on buildings. I suspect most people would find it rather surprising to say that that isn't a matter of public policy, that appropriate cladding should have been put on buildings. Perhaps don't need to say anything more about that. And so one sees that the very example that STC tried to give demonstrates the flaw in their own reasoning. Now, the difficulty becomes, as soon as you open the door to this sort of intervention countenanced by STC's case and permit de novo review of the type that they are talking about, you are undermining the whole scheme. Now, Mr. Chu Choi says, don't be alarmed, board, by Betamax and Mr. Howard talking about floodgates. It's mere assertion. But actually, I'm afraid it isn't. India went down this route and has been heavily criticized. We've referred you to what I think is regarded in international arbitration circles as the notorious saw pipes case. And that is the danger of this approach. It's referred to at paragraph 13.2 of our written case and footnote 11. So this is not an academic point. And bearing in mind the whole purpose of this International Arbitration Act was to make Mauritius an attractive forum for arbitration, the point is actually very important. And now my Lord Hodge's second question was to ask my learned friend, to identify any examples of cases where an arbitrator has just construed a statute and the court has stepped in, as it were, to reinterpret it. Now, yesterday, Mr. Chuchoy was unable to identify any such case. I'll come back to the European case he referred to this morning. But of course, there is a case which is Rockaby, which was particularly concerned with that point. I took you to both the underlying decision in Rockaby, the High Court decision, and the Court of Appeals decision. And you can see that Rockaby was entirely concerned with a question of statutory construction, namely the Securities and Futures Act. I'm not going to go back to that, but Rockaby is a case which is directly contrary to the submission. The only case where one actually finds a court intervening is the Soleimani case. And all of the authorities, both in Singapore and in England, refer to the Soleimani type case. And you'll see the same happened in Senecure. And if one looks at that and looks at the judgment as a whole, I refer you in particular to paragraph 25(4), you'll see Lord Justice Hamblin there gave as an example of the sort of case where the court would refuse to enforce an award on grounds of illegality is Soleimani. In other words, the jurisprudence here is extremely narrow. So in our submission, the true and principled reason why the court cannot review the arbitrator's decision in these circumstances is because once the question of illegality has, in the words of Lord Justice Mantle in Westacre, and those are important words, been made, entertained and rejected, then the court doesn't intervene. At that stage, in the light of what has been made, entertained and rejected, the question for the court is not whether the contract is contrary to public policy, but it's whether the award, in the light of the determinations it's made, having grappled with that question, is contrary to public policy. So the correct delimitation is that findings made on the merits and with jurisdiction, whether of fact or law, are not reviewable. And that is distinguished from the question of law of what the public policy of the forum is. Now, very briefly on the EU cases, before I move on to the question of the scope of the PPA, as I said yesterday, none of the four cases that Mr. Chuchoy referred to says anything about the standard of review. Two of the cases, Claro and Accentuate, are in fact cases about arbitrability and or jurisdiction, where the effect of EU law was that the arbitration agreement was said to be null and void. Now, I won't spend any further time on Accentuate. You will have seen that paragraph 89, I think it is, which made that clear. But all of the cases, all of the three cases to which you were referred, concern EU directives or EU regulations. And as has been pointed out, EU law has a special place in the national legal order of member states, given the principle of effectiveness. The only cases which were English cases to which reference was made was Accentuate, and it's actually interesting to note that Westacre isn't even referred to in Accentuate. I see that Lord Leggett's come back. So they are not cases which are essentially relevant in this area. The SAS Institute case was actually not an arbitration case at all, and it was a case in which the English court had already issued a judgment annulling relevant terms of a contract by applying the software directive. And what then happened was the other side, the party who lost in England, tried to enforce a US judgment obtained in the face of that English judgment and based on those terms being valid. In other words, you had something which was pretty outrageous, is they'd gone to get a judgment in the US, which was in contradiction to the English judgment. So hardly surprising that it was not enforceable. But it's not an authority for the sort of vague characterization of a statute as reflecting public policy, as STC invites you to make. So in our submission, for the reasons I said in opening, this is not a case where the Supreme Court of Mauritius should have got involved at all. It should have respected the findings of the arbitrator. Now, turning to the second question, although it's the question I took first, which is whether, if one gets there, the PPA fell within the exemption, or rather, putting it another way, applying Section 3.2 of the PPA, was the COA an exempt contract? Now, my learned friend largely addressed Regulation 2A, so I will deal with that. But it is important to actually understand how this argument has emerged. As the arbitrator noted, it wasn't at all clear that any argument was being made by STC based on Regulation 2A. They certainly didn't put it before him. It was only on the pleading, and you see that he said he didn't know whether they were running it. It was expressly abandoned before the Supreme Court. This is an argument that Mr. Chu Choi says is abundantly clear and obvious. He abandoned it. The way it emerged in the Supreme Court, and he didn't tell you this, it emerged, his principal argument in the Supreme Court was that the contract of affreightment didn't fall within the types of contract set out in the first schedule to the regulation. What he then said to the Supreme Court, if I'm wrong on that, that was the whole point, if I'm wrong on that, he said, oh, well, then Regulation 2A should have this effect. And you will see that, it's not just my saying it, you will see it in the bundle, pages 868, line 21, to page 869. And also, you'll see that at pages 870 to 871 and page 873. And you'll be interested to note that at page 880...
Mr. Hard, I let you interject with Mr. Chu Choi, so I will do the same. But Mr. Chu Choi, you must keep it brief.
Can I add to the page references in relation to the transcript of the oral submissions before the Supreme Court, pages 874 to 879, please? Thank you.
And in that context, also look at 880, where you'll see actually where Mr. Chu Choi explained that he accepted that Regulation 2A could, on its construction, could disapply the exemption, but he recognized that that was a rather nonsensical definition, position. Now, what did the Supreme Court find? In a way, ultimately, it doesn't matter, in that they, if we get to this point, one's going to have to decide what this means. But Mr. Chu Choi's references as to what the Supreme Court found ignored pages 225, 226, 232, and 233. And he says, I like the word annihilate. I don't like the word annihilate. It's the word the Supreme Court used. Of course, it's embarrassing to find that that's what they said. Now, the references that he took you to are all references to the fact that what the Supreme Court was saying was if the PPA applied, then the COA was in breach of Section 14. Well, that is right. It's not in dispute that if the COA applied. But the question that the Supreme Court was considering was, did Regulation 2A, in their words, annihilate the exemption? And that was the position they took. And that's why when Lord Hodge asked my learned friend, where does the Supreme Court say and explain how Regulation 2A should be limited in the way that Mr. Chu Choi says? They never did, because that wasn't how they construed it. As far as they were concerned, such a question didn't arise. And you can see from the way the matter was put before them how they fell into that error. Now, Yes, my lady, Lady Arden.
Very briefly, this is very brief. Isn't it equally possible that 2A has precisely the opposite effect, and that when it says nothing is to be construed as excluding the application of the Act, what it is saying is, don't read out the exemption given to exempted organisations, which under the Act is for all their activities, by reason of the fact that Regulation 2 has been altered.
Yes, but that is actually precisely what it is doing, and it is the whole reason that you needed to do that, and I explained it yesterday, is because of the definition of public body, which excluded from public body exempt organisation. And when you changed exempt organisation, when the policy was, what we're going to exclude is contracts, not bodies, the danger was that the body whose contracts had been excluded was still an exempt organisation. So it fell outside the Act for other contracts. And that's what the saving provision is doing. It's actually fairly simple once you bear in mind the scheme of the Act. Now, you could say Parliament could have gone about things in a different way, but they didn't want to do that. They wanted to keep this definition of exempt organisation and try and limit what the changes they made. And at this point, I could answer Lord Legate's question as to what are we construing here. We're construing Section 3.2 of the PPA, which takes you to the regulation from the earlier months. So I accept you have to then construe the regulation, but you can understand the regulation because the Act hadn't then been amended in the way that the Finance Act did, and you were stuck with the definition of public body and the exemption, or sorry, the exclusion from public body of an exempt organisation. Once one bears that in mind, the whole thing is perfectly simple and logical. Now, just a couple of other points before I finish. Mr. Chu Choi, one of his submissions is that the schedule to the Act is only concerned with major contracts. That's actually wrong. The schedule to the Act is actually concerned also with identifying public bodies. And you see that from the definition of public bodies on page 2602. So the whole starting point of his argument is actually a false one. It's not just concerned with major contracts. The second point is, Mr. Chu Choi said that the types of contract listed are not every type of contract which is governed by the Procurement Act. Of course, what he didn't do is identify any contract which would be governed by the Procurement Act, which is not covered by the list in Schedule 2, in column 2 of the schedule. And I pointed out to you that at goods, consultancy services and other services are there. The only room for argument of the type Mr. Chu Choi makes is whether one says works and civil engineering works are to be distinguished. And in our submission, they're not. But even if they were, the point is civil engineering works are obviously the main type of works which Parliament had in mind. The next point is that the submissions ignore is that the draftsman was fully aware, both when he or she drafted the 2009 regulation and the earlier regulations in the Act, of the concept of types of contract and the concept of major contracts. And the submissions that are being made largely ignore that. So that's all I wanted to say at the moment on Regulation 2A. As to the point on the true construction of the schedule, first schedule to the regulation, in our submission, the argument is very, very difficult to follow. My friend was asked, what is the rationale? And he never really answered that. What one has to remember is, on his case, a freight contract, a CIF contract, for instance, is covered by the exemption. But what's not covered is if you purchase the goods FOB and you have a separate freight contract. Now, there is no rationale why Parliament would have intended to say freight which is included in the contract of sale is covered, but freight separately is not, particularly where anybody who understands these things would understand that it is going to be most probably more economic for the party such as the STC to purchase freight separately. But leaving that on one side, we say there are two very simple routes by which the court should have held the CAA was covered. Firstly, that where one talks about types of contract, the types of contract which are covered include service contracts incidental to the purchase or distribution of goods for resale. That's a type of contract, and that is what the COA is. And I also draw your attention to distribution. It's very difficult to imagine a service contract which relates to distribution of goods for resale would also be part of the contract to purchase the goods. It's fairly obvious Parliament would understand it wouldn't be. And secondly, the definition of goods for resale, and we've drawn attention to that, and that catches service as is incidental to the supply. And the final point I would ask you to bear in mind is when you look at that schedule, is to consider the position of the Mauritius Examination Syndicate. Mr. Chu Choi carefully didn't answer that. One sees that that refers to goods, including services, in relation to provision of examinations. Sorry, let me just get the...
I think this is a point, Mr. Howard, that you covered in your opening submission. I'm giving you a little bit of leeway because of the 5-minute adjournment. I wouldn't use your time to repeat points you've made.
My Lord, thank you for that indication. I'm going to stop at this point and just ask for your indulgence to allow Mr. Moulin a couple of minutes if there's anything he wants to add on point 3.
Well, you've got 3 minutes to play with to make up for the adjournment. Mr. Moulin.
My Lord, I'm not going to make further submissions on point 3, my Lord. The point is simple. The restrictions set out in section 14 of the Act, as my Lady Arden identified, are not restrictions that go to the object, the objet of the contract. They simply are not. They are restrictions that go to the formation of the contract. And that is precisely why, under the relevant article of the Civil Code, which I showed you, if there is any nullity, it would have been a nullité relative and not a nullité absolute. So this is the simple point, my lords. And I just wanted also to give you references to further translations, which you might find helpful, of the Dalloz on cause, because I took you to one of them, but you will find 2 more translations of the relevant sections at pages 126, 127, 128, 129 of the supplemental bundle. So I invite you to look at them, and they further make clear the points I made yesterday, my lords. This is simply not a cause of unlawful objective cause. It was run below as a case of unlawful subjective cause. The moment that goes, you no longer have a case. Now, one final point, if I may, which is on the application of the International Arbitration Act. It's an easy error to make, and especially at the end of a long hearing. The seat of the arbitration was in fact Mauritius and not Singapore. It was an arbitration conducted under the SIAC rules. Now, the reason, my lord, and I will just give you the reference now, if I may, and that would be the end. The reason why this is an international arbitration under the International Arbitration Act is that it was pleaded in paragraph 15 and 16 of Betamax opening submissions in the arbitration. That's bundle page 1970, that this was an international arbitration because the place where a substantial part of the obligations of the commercial relationship is to be performed outside Mauritius, right? Which is one of the relevant criterion under the International Arbitration Act, Section 2.1. That was pleaded, and then in its oral opening submissions in the arbitration, it was accepted by STC, and you find that in the bundle at page 400, lines 9 to 13. My lord, my lady, I'm grateful for your indulgence.
Mr. Moran, thank you very much. Well, the board is grateful to counsel for their presentation of submissions on a number of complex issues. We are also very grateful to those who have assisted those who have spoken to us in the preparation of the papers and the submissions in this appeal. This is a matter to which we will have to give considerable thought, but we will seek to produce a judgment as soon as is reasonably practical. The board will now adjourn.